Depo Talk, Depo Talk. Another topic broken down on Depo Talk. Wonder what it could be. Let's check in with Jan and Rosalie.
Welcome to Depo Talk with Veritext principals Jan Ballman and Rosalie Kramm. Each episode looks at a deposition or proceeding-related topic of the day through the lens of two industry veterans with over 80 combined years of experience. And now, without further delay, we are on the record. Take it away, Jan and Rosalie.
Happy New Year, friends. I hope 2025 is off to a wonderful start for you. Welcome to another episode of Depo Talk. I'm Jan Ballman, and I'm a principal in our Minneapolis office.
And I'm Rosalie Kramm, and I'm a principal in our San Diego office.
Rosalie, for our first episode of 2025, I thought we could perhaps take a run at a topic that keeps coming up in reporting circles, as well as calendaring departments everywhere. And that is, why do so many reporters dislike reporting arbitrations? And is there anything we could do to maybe address some of the most common apprehensions in an attempt to kind of tamp down some of those tormenting thoughts that seem to plague many reporters when it comes to being assigned an arbitration?
Jan, I would love to tackle this topic today because I think there are a lot of biases out there that reporters have around reporting arbitrations.
All right, I agree with you totally. So why don't we just kick this off by acknowledging the fact that a lot of our colleagues sport the mantra that, if I never have to report another arbitration the rest of my life, that's just fine with me. All right, so from the beginning, what is it about arbitrations that makes so many reporters find them literally abominable?
Well, Jan, I think there are a number of things, and I often get calls from the calendar department asking me to cover arbitrations, everything from a 2-dayer to a 4-week arbitration sometimes. And usually the calendar person is really desperate because so many reporters are refusing to report arbitrations. They're very scared of them. And I think most of the people assigning calendar probably don't fully appreciate the additional dynamics involved in taking arbitrations from the reporter's standpoint. And it probably becomes very frustrating for them.
I think it can certainly contribute to their stress, the stress felt by them when they see so many reporters just turning away arbitrations. Like, what's the deal? Sometimes in favor, of not working at all. I'm sure it's confusing. I remember years ago, I worked for an agency and the calendar assigner would use the phrase pretty liberally, people work is work. Now, she herself was not a court reporter, so she honestly didn't fully appreciate that while yes, all assignments constitute work, not all assignments are the same.
It's so true, Jan. And if you've never been a court reporter, you would not understand why that's the case. So, I'm thinking it might be helpful to give court reporters some fresh ideas on how to approach or prepare to take an arbitration, which could help lessen the anxiety around reporting them.
Well, sounds like a great plan of attack because I do think so many of our fears live, if you will, rent-free in our heads without ever being challenged with eviction. So think of these fears or biases maybe as squatters. They're not going anywhere unless they're made to leave. So yeah, let's start, why don't we, by providing some fresh ammunition aimed at breaking down the most common fears associated with taking an arbitration. So Rosalie, where would you like to start?
Well, Jan, I think there are several things that create worry, and let's just go through them. The first is having an arbitrator or a panel of arbitrators. Sometimes there are 3. And I personally think that actually makes arbitrations much easier to manage.
Totally agree. I know arbitrators can give the feel of being in a courtroom with a judge. And, as a basic concept, most freelance reporters choose not to work in that environment, right? And then we're generally the only official, the courtroom official in the room for most deposition proceedings. And sometimes I wonder if having a superior ranking officer, if you will, kind of running the show can feel a little intimidating, or at least a little different. But I totally agree that for the most part, big tip here, the arbitrator can easily become your new best friend.
Absolutely, Jan, absolutely.
All right, so there's having an arbitrator present that can cause fear. What else do reporters worry about with regard to reporting arbitrations?
Well, Jan, I know I fear this. I think about it, but it's actually just reporting the opening and the closing arguments, statements with sustained writing and sometimes at top speeds.
Okay, legit. That's legit, even though, if you really think about it, freelance proceedings often have very fast tangents in them for prolonged periods of time. So it's not like freelancers never deal with that. We deal with it all the time, but I think opening and closing statements just can go on for pages, and just thinking about that can be stressful. Whereas in a depo, we just don't tend to worry in advance about, well, what if someone starts talking really fast for a long period of time, right?
That's a big part of it, Jan. You know what else reporters do not love? And that is creating the exhibit index of, what's been received, what's introduced into evidence. Sometimes reporters are a little worried about being able to provide daily rough drafts, which is a pretty common request in arbitration. And I'm not going to actually get into dailies when they expedites, because I think that's for another Depo talk. That's an entirely different animal.
Well, okay, I agree. Often arbitrations have specials, as I call them, meaning special services that are wanted over and above just make a record, deliver it to me in 2 weeks, And I think with each special, whether it's rough draft, real time, daily, each special adds an additional dynamic of stress for the reporters. So oftentimes, ARBs have specials. That's fair. Another thing that comes to my mind is that, it's so much easier to fall into like a multi-voice testimony scenario in arbitrations because there's so many people sitting around the table, whereas in a deposition, it's usually just the one-on-one for the most part. So I guess, again, ARBs can feel more like a trial than a deposition. And I think most freelancers prefer depositions to trials. So I think that's one of those biases and fears out there. All right, so actually, Rosie, we have named a couple of triggers around taking ARBs. So now what tips do you have up your sleeve over there to help take some of these, just some of the ARG out of reporting arbitrations?
Well, Jen, let's just start from the beginning. The reporter needs to get either from the calendar team or the noticing party what the expectations are, what the orders are. They're going to actually need to also talk to all parties. And that's both counsel. They need to know what the arbitrator is going to want. For instance, will everyone be receiving all the same services? Do some want rough drafts? Some want real time? And if there's a situation in which the arbitrator wants real time, the reporter is going to need to know that, so they bring enough devices if necessary. And they also may want the rough. The arbitrator may want the rough. And so it's really important for the reporter to know in advance what to expect. Sometimes, because they are many times binding arbitrations, they don't anticipate ever wanting a final transcript. But I've been finding in the last 5 years that all the arbitrations I've been reporting, they do want a final transcript. So I would anticipate that might be the request. So I think that the reporters getting the lay of the land before everybody gets there, or before the arbitration begins, is going to be super helpful, particularly if there's real time. You're going to have to bring extra devices to make sure everybody gets what they need if they do want real time. So you can either ask the calendar person about these things. They typically probably won't know. They might be able to be the go-between between you and the parties, but you're going to need to have that list of questions and make sure you have the lay of the land before you get into that arbitration.
Well, there's a reason why the Boy Scouts have as their motto, be prepared, because, certainly when it comes to taking ARBs, advanced preparation is job one. And that is guaranteed to tame a great deal of trepidation around day one of the ARB.
So now, okay, Jen, so once you've got all the information as to what to anticipate as far as services, you're going to need to get that arbitration. You need to get there early the day of the arbitration, because everyone's going to be setting up. The paralegals are going to be there bringing in their binders, their exhibits. Sometimes they'll hire a tech to display the exhibits up on a wall, which I personally love, because then I can see what they're reading when they're reading at top speeds, let's say. You can set up all your devices, and you'll never regret getting there early, because you might want to enjoy a cup of coffee, and just relax a little bit before you get on the record. And so getting there early is super important. and making friends with the paralegal or the attorneys and asking them for perhaps whatever exhibits that they plan on sharing. They're super happy to give you a flash drive or perhaps link to a Dropbox so that you have access to all the exhibits that they've already marked for identification. The paralegals, the attorneys, everyone there can be super helpful because they really, really want to make the fact that their arbitration is going to go forward smoothly, and they want to help the reporter out.
Yeah, I think so too. Paralegals are super, everybody essentially wants the same thing, right? And that's to end up with a clean and accurate record. So I think for the most part, everyone's going to be on board with making that happen in arbitrations, because when you think about it, sometimes with depositions, that is not the squad goal, right, of everyone in the room. Sometimes opposing counsel is actually trying to disrupt or agitate or railroad the testimony. And of course, all of that wreaks havoc on making the record. So having everyone in the room on board with cooperating to make a good record is actually a really nice benefit to taking an ARB over a deposition. I thought of this. One other thing to be aware of is that, like with any big deposition, maybe where you're taking the star witness and everything is amped. Well, in an arbitration, they're going to be star witnesses throughout, right? These are the key people. This is the trial day. This is the day they've all been working toward. It's a big deal. And so there's a heightened sense of adrenaline that's going to be in the room, and you're going to be able to feel it. So you have to be just prepared for that dynamic.
For sure, Jan. Sometimes you can cut that tension with a knife. Everyone's there with their heightened sense of anticipation. And actually, that's just the reality of the big day arriving for the parties. And I take some of that energy and I put it in myself. And actually, it makes me a better court reporter because I get excited to be there. So as long as you're fully prepared, it's just another job for us.
Well, totally true. I mean, all right. So just to back up for 1 second, we've got everything we need in advance. We're prepared. We arrive early, averting the stress that always comes from being late for any job. You don't need that on day one of the ARB. We've given ourselves lots of time to get organized. Our checklist is in place. What is next on the list of things we can do to make reporting arbitrations less stressful?
Well, let's just talk about that seating chart. Upon arrival, the parties are all setting up, and I'll ask where they anticipate the arbitrator is going to sit. Typically there might be a T with the conference tables, so it's pretty obvious where they think the arbitrator is going to be. And I ask them where they anticipate the witness will be testifying from, where they're going to be sitting. A lot of times they keep changing. There seems to be a new in vogue thing where they change back and forth on either side of the table. And then I decide where it's going to be best for me to sit. And obviously that's going to be facing the witness, sitting by the arbitrator. But a lot of times the people setting up the arbitration room had decided that the court reporter is going to go sit in a corner by a plant, let's say. And I say, no, I really need to be able to hear everything and sit by the arbitrator. And they'll say, well, gosh, there's no room at that table, so we think you'd better be over there. And I don't want to argue with anyone before the arbitration begins. So I just go over, start setting up my gear. And the moment that the arbitrator walks in, I just say, hello, my name is Rosalie Kramm. I'm going to be your court reporter today. And I suggest that I sit by you so that I can hear everything you say and everything the witnesses say. So would you be agreeable with me sitting right here on either side of you? And every single time the arbitrator says absolutely. And the attorneys aren't going to argue at that point. And I don't say, well, the attorneys want me to sit over there, blah, blah, blah. It doesn't matter. Bottom line is I'm sitting where I want to sit. The arbitrator gives me permission. No one's going to argue. And obviously you need to be where you need to be so that you can hear and see everything that's going on. And so I think that's one of the most important things that you should do before the arbitration starts, is to make sure that you are in the place that you need to be able to make a beautiful record.
So that's a really good piece of advice, because basically you're taking charge in a very polite and professional way. And if you're in a deposition suite and the attorneys tell you go sit over there, you're probably going to end up over there. But with the power of the arbitrator on your side, the attorneys aren't going to argue at that point, right? Because everyone wants to be on and stay on the arbitrator's good side. So that's definitely a plus for the reporter.
That's correct. The arbitrator is typically a very seasoned attorney, and you're going to be your best ally in that arbitration. And they're going to call for breaks, tell people to slow down, stop talking at the same time, and maybe even start early or end early to accommodate the court reporter's needs.
Yes, that arbitrator is going to be your best friend. So, all right, do you have any other tricks up your sleeve, Rosalie?
Yes, another thing I advise, Jan, is to ask the arbitrator if they're going to need an index in the transcript, to have that index with all the exhibits when they've been introduced and received into evidence. And I know this is the biggest pain for court reporters in the world. Sure, court reporters that are officials work in court, they're used to doing this, but deposition reporters are not used to doing this, and it's not an easy task. So this is the biggest tip for the day. This is the best news every court reporter out there who's ever thinking about doing an arbitration or might be doing arbitrations are going to hear. Bottom line is no one cares about the index of exhibits. I've asked arbitrators, attorneys in the past if they want them, and they've all said no. It's a waste of the court reporter's time because they're all taking notes. They all are having big charts when things are identified, marked into evidence. A lot of times they have agreements when I'm not even there as to what documents or exhibits are going to be in evidence. So I suggest reporters do not put into an index anything about exhibits. And I've been doing this for a long time. And actually, to be honest with you, I have not provided an index of the exhibits for the past 10 years, and no one has said a word. And so I feel taking that off the court reporter's burden, providing that index is huge. I still do index the direct examination, cross-examination, redirect, recross, etc. And even as an added bonus, I might index where an opening statement starts by a particular attorney or a closing argument is. But bottom line is you do not need to index those exhibits.
Okay, that is epic. Maybe the hottest tip of all time, because certainly not creating that index will relieve a whole lot of stress and work for the reporter. So that's fabulous. That's a great one.
And Jan, just as an add-on, I don't put parentheticals in the transcript either when things are introduced or marked for identification or anything. I don't write anything about indexes or excuse me, exhibits anywhere in a transcript either. But there is a little trick that I'd like to tell you about as far as if there is a witness and they're doing redirect, recross, redirect, recross, redirect, recross. And when I'm actually trying to create the index, I forget like who is this recross, redirect, recross? So what I do now is the first question at that recross, let's say, I put the witness's name in there. For instance, the question might be, where were you when the fire started? And I will write, Mr. Chris, where were you when the fire started? I put the witness's name in there. And that just gives me a tip of who's being questioned at that moment. And to make a verbatim transcript, I can take that Mr. Chris out, but it helps me, saves me a ton of time when I'm creating an index and with those cross examinations and redirects, when it goes on and on and on and on and on. And after a while, you just can't remember who it is that they're actually examining at that moment.
So you write the name, even though they may not say it, and then to keep it verbatim, you just go take it out. So that's I've never thought of that. That's a very hot tip. That I can see that really helping a lot. Okay. Wow. So now we know how to deal with the index, which many reporters might find stressful, but it doesn't have to be. And now no exhibit indexing is amazing, especially since you've time tested this for us, Rosalie, for years and years and have a spotless track record of no complaints. So that seems good enough to bank on. All right, let's jump to the one last factor you mentioned as having an impact on reporters not loving arbitrations, and that is those long-winded, protracted opening and closing statements where the reporter knows they have to endure long periods of sustained writing. Well, my bet is every reporter is way capable of these. It's just daunting to anticipate, right? So what's your tip around that, Rosalie?
Jan, you said it, the court reporters are capable, but you just have to have the mindset of, you know what, I'm going to put my head down. I'm going to take a deep breath. And I'm just going to write like the wind. And you are much more capable than you might think. A lot of it's in your head, and it is hard. It's difficult. You know it's going to end someday, and you just write. And I promise you, you're going to be kind of shocked how much actually how perfect it is, or how great you're writing. And, with the closing arguments, a lot of times the attorneys brief it. So you don't even have to write a closing argument. The attorneys all make an agreement that they're going to just brief it, and no closing argument. So that's really great. And as another tip about opening and statements, closing arguments, is if you are having to provide a rough draft at the end of the day, do not clean up the opening statement or the closing argument, because I suggest that they are not going to be reading that. And when they are reading that rough draft, they're looking at what the witnesses are saying. So don't waste your time cleaning up the opening or the closing statement when you're providing a rough draft.
Yeah. I mean, they're not testimony. And I totally agree. The parties, especially in the throes of things, they're not interested in what they're saying. They're interested in the testimony that they just captured. So totally agree. Wow. I think we've made really good progress here today. We talked about how to overcome many of the factors that can cause stress when anticipating writing or reporting an ARB. But hey, I've got one more question for you. Do you feel that there are any advantages to reporting an arbitration over any other proceeding?
Jan, let's face it, reporting an arbitration is really very exciting. I think it's super interesting because you get to hear the whole case. At a deposition, you hear little bits and pieces, certain witnesses, but here you see how the attorneys put their whole case together. You have the arbitrator making rulings. It can be very dramatic and exciting with the big witness, and you get to see a glimpse of some real brilliance sometimes. And the bottom line is, it can be hard work. It could be long days. But when you think about the fact that you might be providing rough drafts or real time, the money can be pretty amazing. It can be incredibly lucrative. And let's say that you have a really long arbitration, and it's something that maybe you have some dates that you have something that you already had planned to do. And so instead of just not taking a 3 or 4 week arbitration, perhaps team up with another court reporter. And when you do team up, obviously you have great communication, which means that you're sharing briefs and spellings, and it's important to every evening to tell the reporter for the next day who's on the witness stand or who they anticipate questioning next. So having a great communication, but it can really help make an arbitration much less arduous if you have another reporter who you're working with to cover that arbitration.
Totally agree. That's how we usually sign anything with any length at all. Not only does it relieve some of that workload, which is huge, but you also have a backup in the event, you wake up ill one morning, or maybe your child does or something. So it can provide a lot of stress relief knowing you have a backup, and you can go back and forth. Logs at the end of each day. I know that you talk a lot, with each other just by keeping logs that sit right there on that desk. You come back and it has everything you need, the things you've talked about, last exhibit marked, all those sorts of things. So really, the bottom line is that having 2 or more people work on an ARB is really often the way to go to keep the stress level down. The key point, as you said, is good communication, good flexibility with each other. So 2 people or 3 people who work really well together.
Exactly, Jan. I really, really enjoy working with another court reporter on some of the more long, difficult arbitrations. It takes a lot of the stress away. But the bottom line is reporters do not need to be scared or wary about reporting arbitrations. It's really just another assignment. And often they're not nearly as tough as many of us anticipate. Sometimes the workers' comp depo can be more difficult than a day of arbitration. And there you have an arbitrator who makes everyone behave better, keep things moving, and they are usually well worth it from a financial standpoint.
Well, that carries a lot of weight, doesn't it? Well, Rosalie, I think you've made a great case for why reporters should not fear, but rather veer toward reporting arbitrations. And I'm just going to use this as a nice segue to summarize my maybe 2 top takeaways from today. So number 1, ARBs aren't awful if you go in feeling empowered and prepared. The head game is half the game. And then the other takeaway is just, again, you can't overstate befriending the arbitrator. It's job 1 and truly clutch. Think about it. Most officials love their judge because their judge always has their back. And that's what most arbitrators are going to do for you in an arbitration, is have your back.
That's absolutely, Jan, is so correct. And, let's just think, so in summary, reporters, It's 2025. Just do it. Embrace arbitrations. It's a matter of changing the way you think and doing a little preparation.
Exactly. Well, Rosalie, thank you so much for all those veteran tips coming from a whole lot of experience, especially the one that has been time tested for over a decade. That one is amazing. I feel sure that all the intel you've shared today will serve reporters well for the year of 2025 and well beyond. So I think with that, we have a wrap. Happy New Year, everyone. We wish you a year filled with health, prosperity, and happiness.
Jan, I wish everyone out there the best year ever. Court reporters, just go out there, do it, face your fears, be great, be strong. And you know what, Jan? We are off the record.
Depo Talk, Depo Talk. Another topic broken down on Depo Talk.